Second day, and now we'll continue talking about purification, cleaning of authorities, and we will speak about the lustration law and how that law was considered in the Constitutional Court of Ukraine. Our colleagues say that there is sabotage or an effort of revanche, and they will give you details. And one more news from late yesterday. Yehor Sobolev, he's an MP from Samopomich and head of the committee of the parliament on prevention and corruption fight, and head of the Civil Lustration Committee, Karl Volokh, a member of the Civil Council on Lustration at the Ministry of Justice, and a member of the working group on working on law, and co-founder of Civil Lustration Committee, Sergiy Ivanov. He's a blogger, a journalist from Luhansk, and a member of the Civil Council on Lustration by the Ministry of Justice, and a member of the Lustration Committee. And Maksym Mankovsky, he's coming. He's a secretary of the Civil Council. The colleagues, the floor is yours. Good morning. Why we asked to come so early? Because there is some urgent and unpleasant news. You know that the law on the cleaning of authorities was passed last autumn, and it doesn't matter how they blocked it and how they were trying to sabotage it and how top officials were trying to abuse it, and starting with the president of Ukraine, it works. And it is the biggest problem for a big army of corrupted people who are intertwined, who are connected to the previous regime and partially with the regime of Vladimir Putin, and but the most important, and a lot of corruptional links. That law helped to dismiss over 1,000 of top officials and police bosses, prosecution, and from public authorities. It doesn't allow to return to public authorities to such people as Lyochkin, as Boyko, who are sitting in the parliament, and they see that the rating among voters is growing, who are not happy with this government, and hope that to return after the next parliamentary elections. But this law makes it impossible. None of them can be even a patroller, and not talking about a top opposition. Since the first day when the society forced the authorities to approve that law about lustration, about the cleaning of the authorities of the power, they make very creative and very powerful campaign to cancel that law. The first hit on the law, you saw that, that was in December, when the sister of Sergiy Lyochkin, Yulia Lyochkin, asked the Venice Commission to revise whether this Ukrainian lustration violates human rights, and a representative of Ukraine in Venice Commission, Sergiy helped to Venice Commission to understand that, and they built a very negative opinion about our lustration. And the Venice Commission was ready to make an official verdict to the whole world that lustration in Ukraine violates the main human rights, and it's about all communists and about all innocent top officials, and the fault is that they were holding their positions. After that, our Ukrainian courts would be happy to cancel the law in all its manifestations and all the levels. Thank God. Then, just a happy gift of life allowed us to find out about, and together with the Ministry of Justice, we organized consultations for Venice Commission, and now at present they not just cancelled the negative assessment they made previously, but help us to develop amendments to this law, which will cover with lustration all those people who are elected for top positions. You know that lustration includes all who are appointed judges, prosecutors, policemen, tax agents, SBUs, public servants, but those who are elected for positions, they're not covered by that law. That was a requirement of this president and the agreement of the previous parliament. We would like to cover with this law all who are elected to the parliament, all who we will be elected for the president, for the law to clean the authorities, to cover all. And we discuss such amendments. Having understood that they were not able to show in Europe that beastly nature of Ukraine illustration, Mr. Levitchkin and Comrade Levitchkin, they decided to rely on internal reserves. And unexpectedly, even for us, Constitutional Court of Ukraine next week on Thursday, or April 16, they will consider that at the request of three symbolic institutions. The first, to check the law on the prefixture of power, counterintelligence service asked, and that was analytical center of FSB, and the head of Ileshov fled to Moscow right away after Maidan 1. The second request was the majority of judges of the Supreme Court, those who are at the top of the judges' parameter. You don't need comments here. And the third, correct, those wonderful Sois from the oppositional bloc who fled from positions, but they have not fled from the country. They agreed with police, and they got elected to the parliament, and now they are waiting for revanche. All three, they asked the Constitutional Court to cancel the restoration as if it is illegal and inhuman and not honest. There's a big risk that that law will be cancelled by the Constitutional Court, because the Constitutional Court, there are people of Yanukovych. After Euromaidan 1, the parliament replaced the judges of Constitutional Court, which gave dictatorship powers to Yanukovych, and changed the constitution. And then they asked the General Prosecution to investigate that plot of constitutional plot with the participation, and as to the president and churches to call back the representatives in the Constitutional Court. Unfortunately, a year has passed and that was not done. Neither judges nor president of Ukraine changed the representatives in the Constitutional Court. And those people who, at the request of Leonid Kuchma, as he told, who they were handing up people whom he didn't like, they represent Ukraine in the Constitutional Court. At our 12 of 17 judges of the Constitutional Court, they are people of Viktor Yanukovych, including 7 people are those who gave him as dictatorship powers in 2010. The threat that this law can be cancelled is quite realistic under these conditions. That's why we demand from police what happened with the investigation about that usurpation of power and that plot which judges of Constitutional Court they played at the first violin at the beginning of his presidency. On the other hand, we ask from police to report what is done with the investigation of cases against the big abuse of those judges, and we ask the society to defend the law on lustration. We ask only society can demand that this law is approved, and only the society demands that this law is implemented with big battles. Prosecutor after prosecutors, policemen, taxmen, we pull out people who should be lustrated. And the last examples are a prosecutor of Kiev, who was supposed to be kicked under Yarema, and thank God he was lustrated by Viktor Shokin, and offered someone who should be lustrated also for that position. So only the society in that engine which will clean the power, and we need to defend that law on lustration. We ask all to come on this April 16 at 9 o'clock near the Constitutional Court on the Zhelensk Street, and to show that it's unacceptable to cancel lustration. Its risk is very big and it's very serious, and this is why we ask everyone to come and to demonstrate your civic position. And I give the floor to my colleagues, and I unfortunately ran away to a vote in the parliament. Thank you, Yehor. Good morning, colleagues, friends. Yehor told here a lot of those things I was supposed to tell. But I would like to add something, yes. We have this regulation of the Parliament of Ukraine, which was approved on 24th of February last year. Here's the regulation. Paragraph 4 provides to give General Prosecution of Ukraine task to investigate reasons and to give legal assessment of what judges of the Constitutional Court did, who on September 30, 2010, they allowed Yanukovych to use power. Until now, we don't have any decision on this related to this. None of those judges was brought to responsibility, and nobody is responsible, and all the procedural procedures are not done. We hope that the General Prosecutor Shokin will be different from his predecessors, and he will prove that, and he will bring this case until the end. But I personally don't cherish such bright expectations, because despite everything, these are people from the old formation. They don't understand, and they are don't treat this procedural illustration with optimism. Anyway, in general prosecution, they have criminal cases against judges of the Constitutional Court of Ukraine, and criminal cases were initiated because there were signs of crime of Article 109, 110, and there is no decision. Though at my conviction, I am a lawyer, that there are all the reasons. It seems at least those judges who voted from our blacklist, and the 7 of them, and Yehor mentioned, they should be brought to responsibility, and they should not have judges' powers, and they should be brought to responsibility because they developed that mechanism, and they legitimized usurping of power in a modern European country. And that is not one case. It's not just a little case. That's what we demand from the prosecution, and we demand not only from prosecution but also from security service of Ukraine, which got involved in this process. And I will tell you that, in my opinion, those people who created reasons for usurping, a consequence was, as a result, there was a revolution of dignity, and people died. Many people died, and then the war. They have no moral and legal right to practice constitution and law in this country. And from our blacklist, so-called, I know personally those who are from Luhansk region, and I'm also from Luhansk, Zaporozhets, Mikhailo. We have a judge in the Constitutional Committee, Misha Zaporozhets. I know him quite well. His wife, just in case, she was the Deputy Minister of Justice of terrorist organization, LNR. They have a wife, so the security service should get interested, and they should analyze their phone conversations. So this is a case more serious than it may seem. Thank you for your attention. Good luck. Good morning. I would like to draw your attention to how legal this, and it must continue on the next Thursday, on April 16. From the point of view ethical and legal. Look, who collect signatures under those constitutional requests. Yehor told you about counterintelligence source. That's a different question. But look at the Supreme Court. Judges of the Supreme Court, at least a part of them, they are people who have conflict of interest in this case. So even if we don't speak about assets examination, and that is a part of lustration process, and we'll speak about that. Judges are the least prepared to assets lustration, in difference to other top public officials who had to declare the assets. They close to themselves for several years, and they didn't publish the declaration. So they filled some papers and forms, and they sent that to HR departments, and that's where they were. So they considered themselves to be defended, and they didn't care much about what they were writing there and how they would justify there. There are some things you cannot hide. For example, someone buys a car for $100,000. It's impossible not to hide, and because there is in fiscal service, all of that data is available. But because nobody was interested in that, the judges were very calm on this in this sense. Only when the law on lustration was approved, when they were obliged to publish their declarations, it came out they are absolutely not ready. We caught them without their trousers, as Americans say, and we see 6 million, 8 million declarations of presents. So money, they could not justify what they spent, and they couldn't justify presents. That is corruption, and nothing. No other explanations can be given to that. Even if they say that's a present from mother, it doesn't matter. So in such a way, we come to that point when in many judges have a conflict of interest, and not only in the Supreme Court, but all of them. And they have children who are working in courts and law instances, their children are prosecutors, etc. So this is the first part. There is the second part. Many of those judges are covered, them family members will be under the lustration law. One judge of the Supreme Court, her husband was dismissed from work as a prosecutor of the region. Other judge of the Supreme Court was working as the head of the highest qualification commission of judges. He refused to fill the agreement for lustration, and that's a reason to dismiss. The Constitution doesn't allow him without this as the Council of the Justice, which is not formed in Ukraine yet. So what we approach? People who at the time of the Supreme Court who voted for the Constitution to appeal to the Constitution, they have a conflict of interest open. They could not participate in this procedure without special declaration. They had no right to participate in that. So this covers deputies in the parliament. Yes, principle, the law allows them to appeal with and to sign, and nobody doubts the right of this and to ask to do that. But we speak about concrete people who are covered under this law. So deputies are elected to represent interests of people with not their own interest. But in this case, when Lyochkin, for example, when he signs such a constitutional appeal, he has a conflict of interest. He cannot do that just because of that reason. So this is the situation we have. Now let's take the Constitutional Court. At least since yesterday, and there was an investigation, pre-investigation before, examination before, but it was not clear. But since yesterday, when the criminal case is started, usurping power, and they applauded the former President Yanukovych and judges of the Constitutional Court and some public top officials. including the former Minister of Justice Lavrinovich and others. Portnov, probably, clearly, at this point in SBU, they don't have evidence, though they and evidence of judges. But that's the next. So that's clear. Just for you to understand how usurping power of Ukraine looked like. This started from the decision about change the how to build a coalition. Rules how. We remember that right away after Yanukovych took the oath, they started to talk on that issue. What did they give them? They, by that decision, which is absolutely illegal, first of all, because there were decisions, black and white, and of the Constitutional Court about that, and there's international case law, but they changed the order to build coalitions, as you remember, and coalition, how to form it with those people from other factions, and that was the first thing, and that's how Yanukovych could control the government, could build a new majority in the parliament. That was the first stage. The second stage, they in fact took under control the Constitutional Court, though in the first decision we saw the signs that it is they're going to take another control, but on the first stage there was some resistance at the Constitutional Court, but right away the Yanukovych dismissed, and he forced 4 judges to resign from the Constitutional Court. They called the meeting of judges, and who confirmed that, and they dismissed them and elected other people for those positions, and they just pay attention. It's not a known fact, but it is so bright and crying. A meeting of judges, meetings of judges before and after happened, and there were about 500 delegates in 2010 and in 2013, when they had to do all those constitutional violations related to usurping of power. The number of delegates was 100. So they selected the most reliable, who would never undermine and who would never break the schemes Mr. Portnov invented for them. So they started to control the Constitutional Court. Then they took powers from the Supreme Court, which was not could not work on cases. And the next stage was to cancel the Constitution. That's the way they were working. They're trying to mask their actions with blah 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 that they consider laws. And at that law, at that moment, that was a part of the Constitution. There was no law at all. But if you look, if you apply common sense, the country for more than 4 years was living according to a certain constitution. After the decision of the Constitutional Court, that constitution was cancelled, and the country started to live according to a different constitution. The Constitutional Court, despite the constitution and despite the common sense and the world experience, etc., cancelled the constitution. When that is a prerogative of the parliament, constitutional majority referendum, we all understand those tools. That was one, and then administrative reform, during which he dismissed leaders of 73 central bodies of power. Yanukovych did it, and he appointed and also others and their deputies. This, you understand, administrative reform. Not the number of officials changed, not functions changed, and sometimes names, and there was no decentralization and no deregulation. All administrative reform was dedicated, was focused at one thing, to upon the people who are loyal people. And by the way, just against the dismissal, there are people who appealed to the Constitution, they fight against us. So we have the situation, so that 7 judges of the Constitutional Court, they have no right, as participants of these events, people who are affiliated with the previous authorities, to participate in the vote. about the lustration law. Again, through absolutely bright and clear conflict of interest. We will try legally to do something, to take measures, but even if we fail and the time is very short, at least I think that people who will come to the Constitutional Court, they will express their opinion. Why do we care so much? What will happen on that day? First of all, we understand quite well the resistance, especially to lustration. Secondly, there are a lot of signs which say this court is biased. It will do something which was agreed. There are some signs, like small signs, like nobody prohibits the Constitutional Court to consider the law, even if that law is. If even some amendments are planned for that law, but logically, taking into consideration the importance of that law for the society, it makes sense to wait, because those amendments are announced and they will be brought to the parliament next week. But they will not brought to the parliament because of one simple reason: we're waiting for a resume from Venice Commission, and it's quite logical. So experts who are here, they know about those amendments, and they just need to give their resume. So this is an elementary thing. Why not to wait until those amendments are adopted? Why approved? Why not to wait for the resolution of the Venice Commission, conclusions of the Venice Commission, and quite serious lawyers are working on that. Is why. If the Constitutional Court is interested in objective consideration of a case, why are they so in a hurry? I will tell you more. The Ministry of Justice and the Civil Council received only text on 1 of 3 constitutional requests. So they didn't give us time to prepare and to involve experts and to give an answer to accusations against that law. This is a fantastic situation. Why are you in a hurry? Why, if you wanted to demonstrate that you are more or less principle? And also we see whom involve which experts. If they invite experts who for long express open negative assessment of that law, I will not tell you about their interests. But this one-sidedness, this speed, how in a week can you organize a serious conclusions from serious legal institutions? It's impossible. So we see that there is a new plot there, similar to the one they had in 2010. New plot with the participation of the judges of the Constitutional Court. You can just join what Igor told people who are not indifferent, who would like to do achieve a purification, that they should come to the Constitutional Court of Ukraine at the meeting. Thank you. And once I would like to add, please don't qualify it and don't take it as an effort to press, to set pressure on the court, just to achieve one concrete goal. In any case, we will demand that those people who helped Yanukovych to create Jamahiria, so to call it, for them to be brought to criminal responsibility. And it doesn't matter on which side, how they will change their colors, which decisions they make. Those people, they are criminals, and these are 7 people. I can read you the list. Baulin, Brainsem, Davichenko, Hultai, Zaporozhets, Sergiy, Septala. They should know that they are criminals and they must be behind the bars very soon, in a jail very soon. Is there any question? I have a question. April 16th. Constitutional Court makes a negative decision cancels that law, what will be your next steps? What should be done by the society? The society? You as the society, I don't know what the society must do. I know what we will do. Of course, the society will we will inform the society in details. Will give around information through politicians who support and who initiated renovation of our authorities. Will demand these people to be brought to responsibility and for them to lose their positions. What other pressures? Will not go and burn them. We're civilized people, though, you know, this is a point of boiling. Everybody has it, so just imagine the country where revolution of dignity won. The Constitutional Court, at the head of which blessed the president for to be a Tsar. And we have this court. It is under control by a person who's working for Putin. Let's call these things and Portnov, Medvedchuk, etc. So famous Ukrainian lawyers, as Wikipedia says, in Russian Wikipedia says. Thank you. Thank you very much. April 16, 9 o'clock. I would like to near the Constitutional Court of Ukraine. Yes. Yes, that's where we'll see you. Our next briefing will be at 10:30.